Good afternoon and welcome to the Wills Information Session. My name is Ralo Nematayeni. I am a certified financial planner by profession, founder and CEO of EmpowerX Advisory Services. And for this session, we decided let us bring in the experts and talk about the kind of legacy that people want to leave behind. When we talk about legacy, it's all about saying that we are creating wealth, but when we pass on, how would we want to be remembered, or what we would like to leave to those that we love? So today's session is an information session where we will highlight the value of having a valid will in place. I am going to welcome our guests that are joining us today. We've got Ingrid Harris and Debadzo. I'm handing over to you, Ingrid, just to greet the people that are here and also introduce Debadzo, who will be engaging with us this afternoon. Thank you.
Good afternoon, everyone. Thank you so much, Milana, for also welcome in your busy schedules to actually come for this. So I can't say thank you. We are welcome this morning by this afternoon by Maloko. He's our financial, he's our fiduciary specialist at momentum. But he's also a qualified lawyer, so he comes with a lot more knowledge, besides just momentum knowledge, but also specializing in that particular field. And I can't say thank you enough for availing himself. But you're welcome to go into this start the session without further ado.
Thank you very much. Thank you very much for the warm welcome. Just to check, because I couldn't hear Ingrid, am I audible on my side? Is everyone able to hear me?
Yes.
All right. No, thank you very much. Thank you very much. Thank you for the warm introduction. So my name is Tebato Muluko, and I am a fiduciary business development consultant at Momentum Trust, and I'm also an admitted attorney. And the purpose of today's session is obviously just to educate on the importance of having a valid will in place, the dangers of not having a valid will in place, and some of the practical examples that people do experience within our communities because of not being educated about the importance of having a valid will in place, which ensures that you leave a very good legacy behind for your family, and that there is no burden left behind for those you do love. And so I'm quickly just going to share my presentation. Give me a moment. Give me a moment. And then I just need confirmation again if you are able to see my screen as soon as I do share. I'm starting at the end. Is everyone able to see the screen presentation? Thank you. I see a thumbs up. And this is the last will and testament. So I'll be touching on the important aspects of having a valid will, the dangers of not having a will, the effects of, when you do have a divorce, what else is to be done in that case, and so forth. So it's practical examples of things that we do experience in our communities when people pass away without having a valid will in place. And I've themed this: where there is a will, there is a way. So just to take you through some of the contents, I will, number one, take you through Momentum Trust service offering. In other words, everything that falls under the umbrella of Momentum Trust, because Momentum is quite broad, but we do have a division called Momentum Trust, and I will touch on everything that we do offer under the umbrella of Momentum Trust. And then I'll take you through, why should we care? Why should we care about having a valid will in place? Something to introspect about. And then I'll also take you through a brief overview of the estate administration process. In other words, what actually takes place in winding up an estate, especially from an executor that is a professional, what steps do take place and how long does it take to finalize the process until such point as the estate assets are distributed. And I'll try and be as simple as possible and not make it in any way technical, just to make it for everyone to understand. And then I'll touch on interstate succession. So interstate succession is basically where you pass away without having a valid will in place, wherein the law will then decide how your estate is to be distributed because you did not document your wishes on a valid will, or you do have a will, but it's not valid and accepted by the Master of the High Court, wherein then legislation will decide how your estate will be distributed. And I'll give practical examples. I'll also touch on the prescribed formalities of a valid will. In other words, how should a will look like? How, where should you sign and so forth. So these are the prescribed formalities in terms of the Wills Act. In other words, you can have a document that you believe is a will, but if it's not in line with these formalities, then the master might not accept it. And if the Master of the High Court does not accept that will, your estate would have to be administered in terms of interstate succession. I'll also touch on the powers of the courts. Having a document that you refer to as the will, but it's not in line with the formalities, what powers do the courts actually have over such a document? And then I'll touch on executable versus inexecutable wills. And if we do have enough time, at the end of the session, I'll also take you through a case study, basically on everything that we would have touched on throughout the presentation, just to show you how things actually work, and then obviously on to the concluding remarks. So Momentum Trust Service Offering, is everyone able to see the slide? So this is everything under our umbrella. So we've got the Wills Drafting Department number 1. Under this Wills Drafting Department, we've got highly qualified and experienced will drafters who are able to draft your will and tailor it in accordance to your unique situation. So remember, there's one thing to have a will, but is it in accordance to your own unique situation? Is it aligned to your financial planning? A will is a very critical document in that it creates estate planning, and your estate plan has to be in line with your financial plan in order for your will or your wishes to be executed once you have passed on. So it's very, very important that you have a valid will in place, and this will be tailored in accordance to the client specifications. And we use one of the best systems on the market called the My Will system. It's used in many other countries abroad, like Canada, UK, Australia, and so forth. It's one of the best systems on the market, very easy to use. And the reality is, under Momentum Trust, there are actually 3 ways in which you can get free wills. So it's not even expensive to get a will, it's actually free. Number 1, you can actually go onto our corporate website where you use the client direct system, where you just complete a questionnaire on the website and you click submit, and you have a professionally drafted will for yourself, and that will be free. Number 2 is if you have a financial advisor that can utilize the My Will system, and they can draft a will for you, and that will can be free for you as well, provided you do appoint us as the executors for that particular will. Number 3 is if you take out a product called the Estate Provider Benefit, which is obviously created in order to ensure that you have a liquid and solvent estate. So it's very, very important that your estate is solvent and liquid. I'll touch on those 2 aspects throughout the presentation. So that's the first department that we do have, a wills drafting department, where we've got drafters who are senior, legally qualified, and are able to assist you with any types of will. There's nothing complex because of their expertise at back office. We also have a trust department where we've got trust specialists who are able to formulate trusts and register trusts for you in that regard. So for any complex trust or any types of trust that you want to have to safeguard your legacy, there are many types of trusts you can think of. You've got inter vivos trusts, we've got testamentary trusts. I'll also touch on those types at a later slide as we move on. So we do have a trust department to register trusts. We also have an estate department where we also have specialists that wind up estates for you, and they wind it up from beginning to end, and it's very efficient. I will explain this as well when we get to the estate administration process. And then we also take up trusteeship. So if you've got trusts and you want us to be the trustees and administer those trusts and so forth, that service is also available. That we do offer at Momentum. And of course, we do have specialists for those complex queries. So that's the benefit of having Momentum Trust for this fiduciary specialist offering that we do have. And then if you want, if maybe you've got offshore property, any offshore properties, and you want offshore fiduciary services, we also offer that, and we are collaborating with a company offshore that will assist you with anything that you may require offshore. So if you need an offshore will, if you've got offshore property and so forth, those can be taken care of. That's the offering that we do have under Momentum Trust. Just to check, Murado, are there any questions on the floor, maybe in the chat, or should we move on and leave the questions at the end?
There are currently no questions in the chat, but as we continue, I'll be monitoring the chats. And if there's any question that arises, then we can attend to it as we go.
100%, 100%. Thank you. So why should we care? Asking the question, are we doing enough regularly and repeatedly, is very, very critical. So it's something you need to introspect about and think about. Do I have a valid will in place? If I do have a will in place, is it valid? Is it in line with the Wills Act? Can't I get an expert that will review that will and check that this is going to work for my current situation? It doesn't help to say I do have a will, but that will was drafted in 1996 and it hasn't been reviewed, it hasn't been amended, it might not be in line with the latest Wills Act or whatever the case may be, any amendment acts. It's not in line with your unique situations at that point. So it's very, very important that you think about these things and do not fear about thinking about your own mortality. It's very, very important because death is, of course, inevitable. And in this next slide, these are just some of the reasons that people give for not having a valid will in place. And I refer to these as very lame excuses because, like I've already mentioned, there are ways around getting a will in place, and it's not even for the wealthy. So people do not understand the impact of not having a valid will in place. So obviously some of the impacts would be interstate succession. If you look at some of the TV shows that we actually have, like your Giti lights, generally because wills were not left behind to decide as to where the property goes, who inherits this and that. And now we have families bickering over who must do this, who must get this, who must get what, and so forth. So these are some of the dangers of not having a valid will in place. And it's very, very important that we educate each other about the importance of having a will, regardless of where it is drafted. Some people believe it's for the wealthy. Some people believe it's for the wealthy. And we wonder why the wealthy also do not have wills. Then what's their excuse? Because it's not about the wealth that you accumulated that you need to have a will. A will is a very important document that allows you to document your wishes. It allows you to appoint a guardian if you've got minor children and you happen to pass away. It allows you to make provision for a trust for your minor children. It allows you to do many things. It allows you to choose where you want to be buried if you want to be buried. It allows you to document whether you don't want to be buried or rather be cremated and so forth. So a will, it's not even about wealth. It's not even about, it's just about documenting your wishes so that it makes it easier for them to be executed once you can no longer speak for yourself. Like I said, they think it's expensive. That is not the case. It is not expensive. Like I've already mentioned, there are 3 ways in which you can get free wills with us. Number 1, go onto a corporate website, fill in a questionnaire, click submit, and you have a valid will that is professionally drafted. Number 2, financial advisor drafts it on the MyWill system. Number 3, we've got a product called the Estate Provider Benefit, which also comes with a free will and a product that actually helps you to pay for administrative expenses that arise when you do pass away as well. A lot of people in our communities, and this is a reality, we do not want to discuss our own mortality. Death is inevitable, whether you like it or not. Always remember that tomorrow is not guaranteed. You might not make it to tomorrow, and that's a reality. And if we do not plan for that reality, it's a crisis for your family. If we do not plan for that, it becomes a problem. So it's very, very important that we need to face reality and face our own mortality. We are not immortal. We are mortal beings. Some people believe it's for the financial advisor or the professional, the attorney and so forth. The reality is you are able to take a pen and a piece of paper and document your wishes. That you are able to do. As long as what you are doing and that piece of paper is in line with the Wills Act and the prescribed formalities of a valid will. So you will see the prescribed formalities when we get to that slide. But you are able to take a piece of paper and actually document your wishes. And if it's in line with the formalities of the Wills Act, once you pass away, that piece of paper can actually be regarded as your last and final wishes, and the master can actually accept it, and your estate can be distributed as per your wishes. However, a lot of people do not know the prescribed formalities of a valid will, and we don't expect you to know the prescribed formalities of a valid will, which is why we advise that you rather get a professional that will ensure that that document that has your wishes is to the T and on par with the Wills Act. Very, very important. They do not know where to start. This is the reason why we have sessions like this, to empower you on the importance of having a will. So it's very, very important that you get a professional, be it an attorney, be it a trust company. Just make sure that you do have a valid will in place that will be tailored in accordance to your wishes. However, the choice of who you choose to draft your will is also very important. Very, very important. Because not everyone knows how to draft a will, but they may claim to know how to do it. Very, very important. The choice. You need to research the company, research the attorney if you're going to use a law firm, and check their credentials, and if they know what they're doing, and if they specialize in what you are asking for as a service. And I will do it tomorrow. Procrastination. I'm also guilty of that, I'll be honest. I've been drafting wills in momentum since 2019. I only had my own will last year in 2021. If anything could have happened between then, my estate would have been administered in terms of interstate succession. In other words, my own wishes would not be documented. So procrastination is also a problem amongst our people, and it's very, very important that we stop that. Are there any questions so far on the slide? Nothing in the chat?
Nothing in the chat.
Nothing in the chat.
I have a question. I wanted to find out, when you say there's the fiduciary that deals with offshore, does that mean that even people that are in Lesotho and Swaziland, we can be able to do wills for them?
100%. 100%.
Thank you.
100%. Even in Mauritius, even in wherever, we are able to have that offering for them, where we are collaborating with a company that's able to help us with offshore and foreign wills and so forth. 100%. The next slide, I don't want to spend too much time on this one, but this is a slide that just shows you the different indicative age bands and what generally happens within our lives during these particular ages, and why is a will important. So obviously between your 20s to your 30s, you're starting your career, you're trying to pave your career so that you can attain as much productive assets that will ensure that throughout your lifetime, you build a legacy that will sustain the lifestyle that you want to live. So 25 to 35, you're preparing for your career, you're starting a family. 30s to your 45s, you're gathering as much assets, you're trying to create wealth and knowledge as much as you can. 40s to 55, you're consolidating your lifestyle review and so forth, and you're trying as much as you can to ensure that you build a legacy all the way through retirement. So these are all the different stages of your life, and throughout these, a will is a very critical component of a comprehensive financial plan. So you need to have a will to have estate planning, which you can incorporate into your financial plan, because you need a financial plan, number one. And through that, you incorporate estate planning, because now you are planning for after retirement and even after death. So it's very, very important. So this slide is just a discussion that it doesn't matter how old you are. It's very, very important that you do set up a will for yourself to ensure that you leave a lasting legacy and incorporate estate planning in your financial plan. That's about it on this slide. I don't want to spend too much time on this one. And over here, this is just the definition of estate planning. So there are many, many definitions of estate planning, but this is just one of them, which is the arrangement and implementation of a legal and administrative process to ensure that your interests and those you care for are protected during your lifetime and after your death. So there are many, many definitions of estate planning, and all of these explain the importance of preserving and protecting your legacy. That is basically what estate planning is, just to ensure that in your financial plan, you build a legacy that you can leave and protect for yourself while you are still alive, and for your loved ones once you are no longer there. That is basically what estate planning is. And having a valid will and plan in place will ensure that you have proper estate planning, especially if it's professionally drafted and tailored to your current situation. Remember, through Momentum Trust, we ensure that you review your will, you review your estate plan as many times as you want. In other words, where you have a will at Momentum, you can amend it and review it as many times as you want without incurring any additional costs. Whereas we do know that with other companies, it might be you can only do it 2 times a year or once a year and so forth. With us, you can do it as many times as you want without incurring any costs whatsoever. The next one, I'm not sure if you're able to see it, but this next one is basically a brief overview of the estate administration process. And I believe this will be something that we can all engage in, because I'm sure we may have experienced this at some point. This is something that's close to my heart, because I believe it's something that should be part of the school syllabus, although it is quite complex and technical. To wind up an estate, you need to obviously have the experience, you need to be qualified, you need to know the entire process. But this is, I'm just going to take you through a brief overview of what actually happens when we wind up an estate, just to give you a perspective so that you have something to think about, especially when it comes to the term estate planning. So obviously, when you do pass away, when someone passes away, the first thing that we obviously do is we put the house upside down. That's a reality. I'm talking about what happens in our communities. We put the house upside down, trying to find documents. We're trying to figure out, are we going to be able to pay for the funeral? Is there a policy? Is there money somewhere that we can utilize to pay for the funeral and so forth? Something else that we need to do is to obtain a death certificate. Organize all the deceased paperwork that we can put together. Ascertain if there's a valid will in place. So those are some of the things. So if there is a valid will in place and Momentum is the appointed executor in that, the moment we are notified that the client has passed away, we've got legal advisors at back office who will drive or fly to any address in the country or conduct a Zoom or a team session with the family members of the deceased clients. But the purpose is obviously to conduct what we call a preliminary interview. In this preliminary interview, the legal advisor will obviously, number one, read out the will to the family members of the deceased clients, explain all the clauses to ensure that they understand everything pertaining to that will and what the wishes of the deceased are. And number two, they will also ensure that they assist the family members in completing the reporting documents. So remember, when someone passes away, the estate needs to be reported at the master of the High Court. Why? Because we need a letter of authority or a letter of executorship. This letter is there to obviously enable us to, go to these financial institutions and make those claims and so forth and so forth. Without this, we cannot do that. And it's very, very important. Now, the legal advisor will assist the family in completing these reporting documents. These reporting documents can be downloaded on the master's portal, or anyone can have them there available. These will include your death notice, which is just information on the deceased, the date of death, date of birth, and so forth, ID numbers and everything there. There are many other reporting documents that will obviously accompany. It's a batch that would need to be lodged at the master's office, and it needs to be accompanied by the deceased ID copy or certified copy of a marriage certificate if that's applicable. Many other documents will obviously need to accompany these reporting documents. And then from our side, sorry about this, on our side, we need to ensure that we lodge these documents at the master of the High Court, and we do so timeously by obviously looking at the most efficient master of the High Court, which the letter should be issued either within 2 weeks from the date in which we lodge the documents. And obviously we lodge the documents at the master of the High Court. The master will peruse. If they're happy with everything, then they can issue the relevant letter. If they're not, they can issue a query and say, kindly give us clarity on the above, or furnish us with this document, or whatever the case may be. So the master will obviously facilitate that process. Generally, if the master is happy, they will issue either a letter of authority or a letter of executorship. Now, the difference between the two is the value of the estate. If the value of the estate is below 250,000 rand, then the master will issue what we call a letter of authority. Whoever is appointed under this letter of authority can act as a master's representative. Now, the biggest mistake people make within our communities is assuming that if my name appears in this letter of authority, I can do whatever I want. I can own the car, I can sell the car if I want to, I can sell the house if I want to. That is not true. If that's happening within our families, we are actually supposed to report that to the police, because that person is not allowed to do that. They are only acting as a master's representative. Now, like I've already said, it depends on the value of the estate. So if it's below 250,000 rand, the master issues a letter of authority. If it's above 250,000 rand, the master issues a letter of executorship. So that's the main difference between these two. So a letter of authority for small estates that are below 250,000 rand, these are called Section 18.3 estates. Whenever you hear the term Section 18.3 estates, you know that these are small estates that are below 250,000 rand. If it's above 250, master issues a letter of executorship. Whoever is appointed under this letter of executorship can then start the winding up process, number one, by taking and becoming in charge of the estate. Bear in mind, you don't own the estate assets. If your name appears in the letter of executorship, you are just in charge. And you need to consult everyone else when you are in charge. So people assume I am the executor, I can sell the house, it belongs to me, I can do this and that. That is not the case. And that's very, very important to understand. And I know that it happens a lot within our communities where people see their names there because they've been chosen or nominated by the rest of the family members, and they believe, oh, they are the man, and then the family house is sold without consulting the rest of the family members. Because remember, if there is no will in place, what happens? If there is no will in place, there's 5 of us as siblings. This is what's happening in our communities. We choose either the oldest or we choose the male, or we choose the most educated. That's what we do in our communities. And what happens in such a situation, that most educated person will then sell the house without informing us, or do whatever they like because they believe or are under the impression that everything belongs to them, which is not the case. I just thought that was very, very important to highlight just for education purposes, so that if these things are happening within our families or our communities, we need to be aware of these things. And obviously, once you are appointed as an executor, there's certain functions, which is why we always highlight the fact that it's important to rather have a professional executor. There's certain functions that an executor would need to obviously execute. Number one is to take custody of the estate assets, not own them, take custody of the estate assets. That's number one. By the way, being an executor means it's very technical. You need the experience, that's why the choice of your executor, rather appoint a professional executor to assist you in winding up the estate. So number one, take custody of the estate assets. They would also need to do what we call a Section 29 advertisement. Now, this Section 29 advertisement needs to be published in a local newspaper and in the government gazette. This would have been an administrative expense that the estate needs to pay for. The purpose of this advert is to serve as a notice to any creditors that have a claim against the estate, and they've got at least 30 days from the date of the newspaper publication to lodge their claims against this particular estate. What creditors am I talking about? I'm talking about your F&B home loans. They don't care whether you are no longer alive, they want their money. I'm talking about Truworths, I'm talking about Fortini, I'm talking about Edgar's, I'm talking about Nedbank MFC on your vehicle finance. They want that money. And therefore, they will lodge that claim against that particular estate. These adverts are generally in the legal notices at the back, where you see estates that have been published by various attorneys and trust companies and so forth, notifying that so-and-so has passed away. If you've got a claim against this estate, you need to lodge it to this address or number, or whatever the case may be. These are the legal notices that I'm talking about. Section 29 advertisement. Something else that an executor would need to do is to open up an estate-led bank account for the estate. The purpose of this account is obviously so that all the proceeds that belong into the estate are paid into this estate-led bank account, and the executor obviously uses this account to run the estate and pay those successful creditors that have successful claims and so forth. And so that's the purpose of the bank account that is opened for the estate in the name of the estate. Something else that the executor would obviously need to do is to send out letters to various financial institutions, obviously requesting for certificate of balances. I know that's technical, from these financial institutions that these financial institutions where the deceased had dealings with. So what a certificate of balance is basically a certificate that's going to be issued by financial institutions. For example, Capitec Bank is going to come forward and say, this client had 50,000 Rand in their savings account with us. FNB is going to say, this client had so much with us, and so forth. Nedbank will do the same, ABSA will do the same, the rest of the financial institutions will do the same. And these certificate of balances will be sent through to the executor, and the executor will use these certificates as vouchers when they draft what we call a liquidation and distribution account. And obviously this liquidation and distribution account would need to be lodged at the Master of the High Court. So I know it's very technical. I want to simplify it as much as I can. Something else that the executor would need to do in that very letter that's sent out to the various financial institutions is to ask them to close off all of those accounts and to pay in those proceeds into this estate-led bank account that would have been opened by the executor. So very, very important. That is the purpose and function of sending out that letter. Something else, obviously, after gathering all that information, the executor is able to determine whether solvency and liquidity. Now, obviously, solvency is where assets exceed liabilities. That's solvency. Liquidity, on the other hand, is asking, is there enough cash in the estate to pay for administrative expenses? So remember, when someone passes away, it's not just the funeral that needs to be catered for. There are administrative expenses that you need to make provision for, which is very, very important, because if you do not do that, it's a burden on the loved ones that you leave. So like I've already mentioned, solvency is where assets exceed liabilities, which is good, which is what we want. Liquidity is cash. Is there enough cash in the estate? Now, there are many, many instances where you find that estates are solvent, but there isn't enough cash in the estate for administrative expenses. One's probably asking me, what administrative expenses is this guy talking about? I'm talking about executor's fees. So whoever's appointed as an executor is entitled to fees, and they need to be paid either 3.5% of the value of the estate, or whatever amount is fixed in the will if there is a will in place. I'm talking about master's fees. The master of the High Court needs to be paid fees as well, because they've got an advisory function, they've got a supervisory function, and they've got an administrative function. So it's very, very important that we obviously be open and make provision for these expenses. I'm talking about conveyancing fees. Conveyance, so if you've got a property and you need to transfer it to your beneficiary, that's an administrative expense, and you require a conveyancer to do that. So once you are no longer there, in order for that house to be transferred into your beneficiary's name, your wife or your husband's name or your children's name, that is what I'm talking about. These are administrative expenses that need to be catered for. And unfortunately, in most cases, you find that there are estates that are solvent, where assets exceed liabilities, but there isn't cash. And that's a nightmare for any executor, because now they're left with a few options. Either they need to get rid of that Mercedes-Benz or that BMW in order to ensure that there is cash. They need to dispose of something, or ultimately the beneficiaries may also have to inject, if they are able to do so, some of their own monies into the estate to ensure that we are able to wind up the estate. So that's very, very important. I just thought I should touch on this briefly, solvency and liquidity issue, when showing you what basically takes place in winding up an estate. Remember, winding up an estate in a perfect world, 9 to 12 months, sometimes even over a year to finalize, sometimes even less than a year, depending on the merits of each estate. Some are very straightforward that you can finalize much sooner, and some are actually quite complex and can take up to 12 months or even over a year, depending on how complex and what the merits are of that particular estate and so forth. Are there any questions so far?
Yes, we have questions on the chat. Thank you very much for explaining this, because it speaks to the first question. So the question says, people keep saying a will is free, but I don't think so. What is the catch? And why are they a condition that you must choose whoever is assisting you as an executor? What do they get? Is there a percentage they get from your estate? Is the rate standard, or does it differ?
100%. No, that's a very, very good question. So remember, we are drafting a top quality will, number one. We are using one of the best systems, safe to say, in the world, because it's an international system that we do utilize. It's one of the very best. Now, given that service for free, we do it on condition that you appoint us as the executors. This gives you an opportunity to have us as these professionals wind up your estate from beginning to end and make it very simplified for you. We are able to tackle whatever complex estate there is, and our track record does speak for itself. So the reality is, yes, will becomes free, but then there are fees once you do pass away, depending also. So we rely on there's a section 51(1)(a) and (b) of the Deceased Estate Administration Act, wherein it says Whoever is appointed as the executor, A says, is entitled to any amount that may be fixed in the will. B says that there's no amount fixed in the will and executor is entitled to 3.5% of the gross value of the estate. So that's basically how it is.
Thank you very much for that answer. And there was a comment to say, who knew that dying was this expensive? So people might just not do it. And then the next question, it says, if someone has their son as the beneficiary of their life insurance in their will, and their uncle as a beneficiary in the life insurance, so there's a discrepancy between the will and the information on the life insurance company, which one takes precedence? So the son is on the will, and then the uncle is a beneficiary on a life policy.
That's a very, very good question. Can I answer that in the next slide? Because that would have been our follow-up slide where I'll be showing you the different types of estates and asset frameworks within the 4 buckets to differentiate between your personal estate, your life policies, your pension funds, your trusts, and so forth. So that would have been our next topic.
Okay, thank you.
Yeah. Other questions?
No, that is all for now.
All right. Okay. So this particular slide I've already touched on, cash shortfall, meaning the estate there isn't enough liquidity in the estate, and obviously this amounts to 70% of delays in winding up estates where you find that the estate is actually solvent, but there isn't enough liquidity. So whenever you hear that term cash shortfall, it means it is a solvent estate, but there isn't enough liquidity in the estate to pay for those administrative expenses that I was talking about. So it is expensive to die, and it's not just the funeral that you need to think of. It's these expenses that I'm talking about that you need to cater for. And there are many ways to cater for those expenses. And like I said, from our side, the estate provider benefit, which you can obviously take out, wherein we are able to do a calculation based on tariffs. If you're talking about conveyancing, based on tariffs. If you're talking about master's fees, looking at the value of your estate and the assets that you do have and the policies that you do have and your liabilities, if you want that product to cover for any of your liabilities, like your outstanding home loans and so forth. So then maybe that's a topic for another day where we can have a follow-up session on the estate provider benefit. But I just thought it's very, very important to highlight. The slide I've already discussed when I was in the other slide as well. Now, to answer that other question, this is the particular slide that I was talking about, the question that I didn't answer just now. So this slide, these are what we call the 4-bucket asset framework. And it's very, very important that we are able to distinguish between these 4 buckets. So a will is very, very important, but does it cover all these 4 buckets? And the answer is no. It does not form, it doesn't cover all these 4 buckets. So I'll go through each of these buckets just to explain them. So let's start with the first bucket, which is the personal estate. So anything that forms part of your personal estate. What am I talking about? Personal estate, I am talking about your immovable property. What do I mean by immovable property? I'm talking about your house. I'm talking about movable property. I'm talking about your cars, your furniture, household contents, and so forth. That's movable property. I'm talking about your claims in favor of the estate. What do I mean by claims in favor of the estate? I'm talking about the money in the bank, your accounts, your Capitec, your FNB, your everything that forms part of your investments. These are claims in favor of your estate. All of these form part of your personal estate. In your will, you are able to decide what is to happen with everything under your personal estate. I'm also talking about those policies where your estate is nominated. In other words, those policies that are payable into your estate. those you can deal with in your will. So that's the first bucket, personal estate. So it's immovable property, movable property, claims in favor of the estate. These form part of your personal estate, and in your will, you are able to decide what is to happen within your personal estate. The second bucket, which is your deemed estate, these are life policies where you actually have nominated beneficiaries. So what am I talking about? It's when I say I have a policy, so-and-so is a beneficiary. That does not form part of your personal estate. It's a contractual agreement between the insurer, the life assured, and the beneficiary. The moment you pass away, this policy is paid directly to that beneficiary. And these beneficiaries are also protected from any creditors. In other words, there's a section called it's a Long-Term Insurance Act, Section 63, which basically says it's a very technical legal term called stipulato ulterior, where the benefits of those beneficiaries are protected from creditors. So it's a contractual agreement between the insurer, the life assured, and the beneficiary. So it pays directly to those particular beneficiaries. And in your will, you cannot say, I want that policy to pay to so-and-so when you've got nominated beneficiaries. That you cannot do. And so in your will, you cannot deal with the second bucket, which is your deemed estate. In other words, these life insurance policies that have nominated beneficiaries. I'm assuming that probably answers that question that we got there.
Yes, there's a comment that says I'm covered.
Okay, thank you very much. And then we have the third bucket, which is the pension type or retirement assets. Now, these are dealt with in terms of Section 37C of the Pension Funds Act. Now, obviously, you are able to nominate your beneficiaries. You are able to nominate and list your beneficiaries to receive your pension funds. However, the trustees of the pension funds have the final decision. In other words, they've got the final discretion to decide what's to happen with those. And they conduct investigations and so forth, look at your beneficiaries, study the situation, and it's a process that can take up to 12 months. I'm not saying it takes 12 months, it can take up to 12 months to finalize because the trustees will be conducting investigations. And the trustees are able to say, assuming you've got 4 children, number 1 and number 3 can get greater portions because of their financial standings, maybe a little bit poorer than the number 2 and number 4, whatever the case may be. So they have the final discretion. You are able to obviously make recommendations to them, but they've got the final decision to say, this is how it will happen. So-and-so will get this portion of the pensions and so forth. That is in terms of Section 37C of the pension funds. And it obviously can go against your nomination. And then we've got the last bucket, which is the trust estate. I generally speak about 2 main trusts under this bucket. So by the way, let me say this. In your will, you cannot deal with your pension or retirement assets. It does not have the authority to do that. The discretion lies with the trustees of the pension fund. 4th bucket, the trust estate. In your will, let's be clear on that one. In your will, you are able to make provision for the creation of what we call a testamentary trust. Now, a testamentary trust is a trust that is created after your death. Having made provision in your will, having stated in your will that I want a trust to be created for the benefit of my minor children or my elderly parent or whatever the case may be, or my disabled child or whatever the case may be. You are able to do that in your will so that they do create the trust. And the benefits of that is that, remember, if you've got minor children cannot inherit in their own capacity because they cannot handle their financial affairs while they're still minors. if you do not in your will make provision for a trust, then your estate may be reduced to cash and paid over to the Guardian's Fund. The Guardian's Fund is a department at the Master of the High Court, and whoever you appoint as the guardian of your children in your will have to approach the Guardian's Fund from time to time, requesting monies for school fees, for clothing, anything that the child obviously requires in that regard. And that is obviously the purpose of a testamentary trust, created only after your death and so forth. And then there is also what we call an inter vivos trust, which is actually a living trust, wherein you are also able to have it while you're still alive, and you are able to run it while you're still alive. You are able to buy properties under this trust, and it does help in terms of your personal estate. So if you've got things under a trust, it reduces your chances of estate and taxes and so forth, other taxes and so forth. Executors' fees are also lowered and so forth when you do have these things under a trust. And it also protects your legacy, in that if anything goes wrong under your personal estate, at least these properties are under this trust and cannot be touched if anything goes wrong within your personal estate. And that is the main aspect I wanted to touch on, being able to differentiate between these four buckets. So there's a personal estate, there's a deemed estate, which is basically life insurance policies with nominated beneficiaries, and there's pension funds, which are obviously in terms of the Pension Funds Act, and we've got the trust estate, which these are the different buckets that we need to be able to understand and differentiate. And in your will, you are able to deal with just your personal estate, and you can make provision for the creation of a testamentary trust. So testament basically means will. So if you hear testamentary trust, is a trust that stems from your will, where you've in your will stated that you wanted a trust created for the benefit of your children. Are there any questions so far?
The question that was on the chat was referring to the deemed estate and saying what happens if the beneficiaries are minors.
So these deemed estates where the beneficiaries are minors, the good thing about that, if you've made provision in your will for the creation of the trust, it can be held in the trust for the benefit of those minors. And then obviously under this testamentary trust, you are able to state that you want them to receive it when they are 18, when they are 25, or you can, third option, opt for partial releases of the capital, and say you, for instance, you want them to receive at age 21, 30%, and then at age 26, when they're more responsible, the remaining balance, and so forth. So you are able to do that.
Thank
Makes
you.
sense. All right.
Yes. And still on that, there's a question that says, as far as the trust goes, can I order that they pay directly to the kids' school fees and so on and so forth?
So, yeah, that's a good question. The trustees will definitely facilitate that process. So the guardian will say, hey, this is the school fees, and then it's paid out by the trustees of the person. So they three parties within a trust. It will be the founder of the trust, it's the trustees, and it's the beneficiaries. So the trustees ensure that the well-being of the child are taken care of, and they are able to facilitate that. And obviously there are trust deeds that will ensure that, so trust deeds will be drafted, and obviously you need to agree to that trust deed and so forth. And if all goes well, you are able to do so in the trust deed and say, this is how I want it to happen and so forth. You are able to do that in your trust deed, and the trustees will then, because they are professionals, facilitate the entire process.
Okay.
And the good thing about a trust, by the way, is that, remember, once there's something coming into trust, it's invested in a high interest account. And obviously, once the trust terminates, there's even more money because of the interest that was accumulated from that.
Okay, thank you very much. And if no will has been done or provision for the trust, So what happens in that case when there's no will or provisions for the trust? And if no trust is created, can the school fees still be paid directly to the school?
So that is the danger of dying without a will, because you do not have a will that says, I want a testamentary trust created. Whatever it is that would have gone to the trust goes to the guardian's fund. That means whoever is the guardian of your minor child has to go to the master of the high court, stand in the queue at the guardian's fund section. Chances are they might cut the line and say, hey, Naria Chaisha. That means they're closing, come back tomorrow. Tomorrow, same thing might happen. That's why I'd rather have a professional trust created for you, rather have a will in place while we still can. Because you do not have a trust, if you don't make mention of that in your will, or you don't have a will, it goes to the guardian's fund. Not that you're losing by that, it goes to the guardian's fund and you need to go to the guardian's fund and ask for the money. And it's a process.
Thank you.
No other questions? Okay, I see a thumbs up. Just to check the time, are we still within time? I see we're behind time. It's fine, we can continue if everyone is happy with that.
Yes, we can continue.
Okay. The next topic is interstate succession. So remember, if you die interstate, it means you die without having a valid will in place. And if you die testate, it means you die with having a valid will in place. So interstate succession is where legislation actually decides what is to happen with your estate because you died without having a valid will in place. And these are some of the dangers. I'll take you through some of the practical examples. And there are many, many instances where you find that a will cannot be found. If it's found, maybe it's not signed or incorrect or poorly drafted, resulting in confusion as to who inherits what. And in that case, your estate would be administered. I've been saying this in terms of interstate succession. And the picture on the left is just a practical example of almost what happens when you do die interstate, where you do not have a valid will in place. And that's why we have shows like Gugiti La, people bickering over houses, bickering over things because there is no will in place. And according to the Master of the High Court, it is estimated that up to 70% South Africans do not have a valid will in place. 70%. Before lockdown, I think we were sitting on 80-something percent or 80%. That's the beginning of 2020. And these were the stats given by the Master of the High Court. And this is not unique. 68% of US citizens also do not have a valid will in place. And these are people that should be having a valid will in place. Also not unique to the general public. Even famous people died without having a valid will in place. We've got your Prince, Aretha Franklin, Amy Winehouse, Bob Marley, Sonny Bono, Kurt Cobain. List is endless. One in particular I've been following is that of the famous American singer Aretha Franklin, where her estate is still not finalized to this day. Why? There was one will that was found under a mattress, appointing a specific executor, but it wasn't signed. Another will was found around the house, appointing someone else as an executor, and it was signed but not dated. Another will was also found lying around somewhere in the house. So all these three wills appointing three different executors, and it's now a debate. It's a fight, it's a bicker between the children in trying to figure out who is the executor. And these are three wills that are saying different things. And these are some of the dangers. That's why I need to emphasize the choice of who your executor is very, very important. The choice of who drafts your will is very, very important. So do a bit of research before just going to anyone just to draft your will. You need to ensure that they do specialize in these things and they know how to facilitate this process. In most cases, if they have a safekeeping facility for that will, it makes everything easier, as opposed to having a will lying around in your house in which it might land up in the wrong hands. So it's things we need to think about as well. And obviously, if a will is lying around but cannot be found, interstate succession will apply. And obviously, I want to give you practical examples of interstate succession, which is obviously where the deceased has not executed a valid will or has not dealt with all their assets in that particular will. So just to give you some of the examples, if the deceased is survived by the spouse only, the spouse can be the sole heir, which is fine. And that is interstate succession. If the spouse is survived by the spouse and children, interstate succession also decides. So the spouse will either receive 250,000 rand or a child's share, whichever is greater. Now, what do I mean by a child's share? A child's share is basically taking the value of the estate, dividing it by the number of children plus the spouse, and that will give us a child's share. Now, if we take the value of the estate, dividing it by the number of children plus the spouse, if that amount is above 250,000 rand, then the spouse will receive a child's share. If it's below 250,000 rand, then the spouse will receive 250,000 rand, and the remaining balance will be divided equally amongst the deceased children. That is interstate succession. Just to give you another example, if you are survived by parents, no spouse, no children, your estate is divided into half. Half is given to your mother, the other half is given to your father. By the way, this is regardless of whether you've got a relationship with either of the parents. In virtue of you not having a valid will in place, interstate succession says these are the people that would receive from your estate. These are the dangers of not having a valid will in place, by the way. If you are survived by one parent, let's assume this is your mother, no spouse, no children, again, your estate is divided into half. Half is given to your mother, the other half is given to all your father's descendants. What do I mean by descendants? I'm talking all your father's children. They will receive what their father would have received. That is interstate succession, and these are the dangers of dying without having a valid will in place. By the way, this could be people you didn't even know existed. These are the dangers of dying without a will. So half will be given to your mother, the other half will be given to all your father's descendants. Now, some of the questions that do pop up is, how would they know they are entitled to? Remember these legal notices at the back of these newspapers. They're gonna know, hey, if there's no will here, my father would have received a share, so I can have a claim and get my share or my portion in that regard. That is interstate succession. Other interstate succession conditions: if you have no spouse, no children, no parents, again, your estate is divided into half. Half goes to all your mother's descendants. In other words, all your mother's children. Other half goes to all your father's children. Again, this could be people you haven't seen in years. This could be people you don't even have a relationship with. These could be people you don't even like. These things happen. With siblings, half siblings do not get along. It's a reality. But if you don't have a valid will in place, there's a risk of them inheriting from your estate. These are the dangers of interstate succession. Dying without a valid will in place. If your parents are not survived by descendants, then your estate would go to your nearest blood relative. And you know what that means, right? It could be that one relative you haven't seen in 20 years and you don't even like. It could be that relative that you've been accusing of witchcraft. They stand to benefit from your own estate. That is life, because you do not have a valid will in place. And these are obviously the dangers of dying without a will in place. I really hope this is an eye-opener for some of us. For those of you who don't have wills, of course. Now, if no blood relative can be traced, the inheritance will be paid to the guardian's fund. And if it is unclaimed after 30 years, remember the guardian's fund, if you've been watching the news lately, the guardian's fund is very notorious for monies disappearing within that fund. And that's a reality. You don't need to sugarcoat it or anything. That's been happening, where monies just disappear. So no relative traced, paid into the guardian's fund. Unclaimed for 30 years, it will be forfeited to the state. So chances are it might not even make it to the 30 years, it will be in someone else's pockets. So imagine working your entire life just for your estate to be paid and taken by someone else. Something to think about. These are the dangers of dying without having a valid will in place. Any questions? So these are just conditions that I chose for interstate succession. So just to check if there are questions.
Yes, we've got about 3 questions, but I'll start with this last one, where it's related to interstate succession, to say what happens when you have your siblings and then you are married A and C, no spouse, no children, no parents.
So just say that again. I just want to draw a picture in my head.
What happens when you have your siblings?
Yeah.
And then you are married A and C.
Yeah.
No spouse, no children, no parents.
Okay. Then your spouse will be the sole heir and everything will go to your spouse. So this is what happens in terms of interstate succession. The first person to receive from interstate succession is your spouse. If your spouse is not there, it goes to your descendants. If your descendants are not there, it goes to your ascendants. So descendants are your children, ascendants are your parents. So number 1 is your spouse, number 2 is your children, number 3 are your parents. That's how it works. Does that make sense?
Yes,
All right.
it makes sense.
Okay.
And another thing, there is I think the question we all came here waiting for. It says, oh yeah, let's start with this other one. Is there a requirement for opening a trust? I think we can start with that.
So opening a trust, it depends on the company that is registering the trust for you. Some would say you must have at least 1 million rand. Some might say there's a certain amount that they may choose. So it depends on the company that is obviously assisting you in setting up that particular trust. With Momentum, I think it's at least 1 million rand that you can open a trust where it can be invested for you in an interest-bearing account when the trust has been set up. I'll quickly find out from our trust specialist what the actual amount is, but I think it's around there.
Okay, thank you very much. 2 questions are related. It says, is there a difference between a will from the bank and Momentum? And the other question says, wills from the bank, what are the disadvantages? I've heard stories of how bad they are, yet so simple to draft.
Am I allowed to talk about our competitors? That's another question. Am I allowed to do that? I need to tread carefully there.
I think just to be safe, not mention names, and also not mention the name of the products that they have, because if you say how they call it, then they're gonna know.
Yeah. So the reality is there are a couple of banks where the quality of their wills have been very, very questionable. That's a reality. Once they are lodged at the Master of the High Court, in some cases, they are declared invalid. Having been drafted by them, they are declared invalid. And if they are declared invalid, you've got a few options. And that's also another topic I was going to touch on. You can approach the High Court to try and compel the master of the High Court to accept that invalid will from the bank. And that's not even a guarantee. It's actually a slide I was going to discuss at a later stage as well. So if the reality is that the quality of some of the wills that are drafted there are appalling. So do a bit of research. Do some research, and it does help if you do a bit of research on there, because some of the quality of their wills can be appalling. And remember, if the master says it's invalid, we're not accepting it, this is how your estate would be distributed, interstate succession, unless you want to approach the High Court, which is expensive, by the way.
Okay, thank you very much. I think there's a, let me go to the previous question where they were asking about, do we have to initial and sign all pages of the will or specific areas?
That's a question also. It's basically the prescribed formalities. It's something I was going to touch on in the next slide. So I'll answer that in our follow-up slides.
Okay, and then last one, are you saying the wills from the banks are invalid?
I didn't say that. I didn't say that. I am not saying that.
Okay, thank you. Those are the questions we have so far. Can continue.
Okay, please do not misinterpret me. I did not say wills from the bank are invalid. No, I didn't say that. And I'm not saying that.
Thank you for that clarity.
Yeah. And obviously, consequences of having no will in place. Number one, interstate succession, which we've already discussed. Number two, your wishes may not be met. In other words, you cannot execute your wishes if you do not have a valid will. Next thing, you are cremated and your wish was to be buried. Or you are buried in Pietermaritzburg and you wanted to be buried in Polokwane and vice versa. You know, things like that. No opportunity for active estate planning. In other words, if you've got a financial plan and you've got your financial advisor there, obviously, we are there to ensure that you have an active estate plan. If you acquire new property, we amend your will. If there's a change in your marital status, we amend your will so that it's aligned to your unique situation and it's tailored in accordance to your wishes and obviously in line with your financial plan as well to ensure that that particular will is executable. So if you do not even have a will, you won't have an active estate plan. There is no executor appointed. So this is where we sit in that family meeting because our parents are now gone and there's 5 of us and we either choose the male or the most educated or the oldest. And then they are the appointed executor or their name appears in the letter of authority. And then before we know it, the family house belongs to so and so and we can't even enter the gate. These are some of the dangers. You can't even appoint an executor. No guardian for your minor child. In most of our communities, I mean, you always assume that my mother's sister is my mother, but that's not the case in every family. You might assume your sister will take care of your child, but once you are gone, your sister's like, I've got my own kids to take care of. And then what happens if it's awarded to the guardian, they take the money that should go to your child and use it for their own children. These are the things that are happening within our communities. And that's why I like giving practical examples. So it's very, very important when you have a will in place, everything can be said. And obviously, it takes away from you an opportunity to make provision in your will for the creation of a testamentary trust so that a professional trustee can take care of that portion of the estate for the benefit of your minor child. So these are the things that we need to take care of and think about. If you do have a valid will in place, think about these things. And obviously, like I said, caution interstate succession, family disputes, inheritance to a minor. So these are things that we've obviously mentioned. Prescribed formalities. This is also going to answer one of the questions that I think I said I would answer later. Basically, prescribed formalities are how a will should look like in terms of a will, in terms of the Wills Act. So these questions or the answers to these questions are what we refer to as the prescribed formalities. Who qualifies to be a testator? How should a will look like? Where do you sign? How? Who can witness? How should they sign? What happens in the case where you use a mark instead of a signature, and so forth? The answers to these questions are what we call the prescribed formalities. Now, if you have a document that you've jotted down to document your wishes and it's in line with the answers to these questions, then you are all right. Then that will or that document can be accepted by the Master of the High Court as your last and final wishes. Now, who qualifies to be a testator? Now, a testator, oh, by the way, testator, testatrix. A testator is male, testatrix is female. So that's the difference between the two. Testator is a male, testatrix is a female. The testator or testatrix must be at least 16 years or older. The will must be signed by the testator or by someone else in the instruction of the testator in the presence of the testator. In such an instance where someone else signs on behalf of the testator, a commissioner of oath would need to commission the will to satisfy themselves as to the identity of the testator. The will generally signed at the end of every page. Who can witness? The will must be witnessed by at least 2 competent witnesses who are at least 14 years and older and are able to give evidence in a court of law. Something very important about witnesses. Do not have your beneficiaries witnessing your will, because if you have your children or any of your beneficiaries witnessing your will, then they are automatically disqualified from inheriting from your estate. So none of your beneficiaries should witness your will. Whoever witnesses your will does not have to know the contents of that will. The 2 competent witnesses, or at least 2 competent witnesses, must witness the will in the presence of each other and in the presence of the testator. The job of the witness is just to witness the will that they saw the testator sign it. They need to be in the presence of each other and in the presence of the testator. So you can't have one testator in Polokwane and the other, you can't have one witness in Polokwane and one witness in Giyani. You can't have that. They need to be together in one room, signing at the same time in the presence of each other. In other words, the testator or the testatrix and the 2, or at least 2 witnesses. I repeat, none of your beneficiaries should witness your will. Like I said, will generally signed at the end of every page. In the case where you use a mark instead of a signature, again, the commissioner of oath must commission the will to satisfy themselves as to the identity of the testator. And these are the prescribed formalities of a valid will. These are the prescribed formalities of a valid will. If they are in line with the answers to these questions, then your will is on par and can be accepted by the Master of the High Court. It's not really a requirement that the will should be dated, so it's not in terms of legislation that a will should be dated. However, we strongly advise that your will is dated, because you have people having a will in 96 and then another one in 2001 and then another one in 2020 and another one in 2022. The latest will is the one that we regard. So if your will is not dated, it makes it difficult. So we strongly advise that you do date your will. And these are the prescribed formalities. Are there any questions?
There's a burning question.
Okay.
How do you cancel your will if you want to use another provider?
As long as the new will has the latest date, that other one is already cancelled. Dating your will basically cancels the wills before.
Yes, so there will be a clause stating that all other wills.
100%.
And then there's a question here that says, we spoke about the beneficiary not witnessing the will. And then the question now it's saying, can my husband be an executor and also witness my will?
That is a very, very good question. Your husband, if your husband is a beneficiary, they cannot witness their will, your will. They will be disqualified from inheriting. There are certain people that can be appointed as an executor, and this is in terms of the Master of the High Court as well. And these people, by the way, will be exempted from furnishing security to the Master of the High Court. The parents of the deceased can be appointed easily as the executors. The spouse of the deceased can also be appointed as the executor. The children of the deceased can also be appointed as the executor. So these are the three people that can be easily appointed by the Master of the High Court as the executor.
So can the executor also witness the will?
Nope. That's a
Okay.
conflict of interest, yes. They cannot witness the will. As an executor, you cannot. Rather get a complete stranger to witness your will.
Okay, and then the last question that we have here is, how often should we update the will? Is it every year, every 2 years? Or as and when life and death events happen?
In my opinion, as often as you can. Whenever there's a change in your life, update your will. Like I said, change in your marital status, update your will. Additional member of the family, update your will. Acquiring property, update your will. As many times as you can, do it. But obviously, through momentum, we allow these changes without incurring any additional costs. These amendments, in other words. Not every company allows for those amendments. A lot of them will say at least 2 times a year. And if it's beyond that, you might have to pay for those amendments or changes in some trust companies, in some banks as well. Makes
Thank
sense.
you. Yes,
Right.
that's all the questions we have for now. And just to state, okay, there's a comment that I put there to say, it was a question to say, are you part of the 70% without a will or part of the 30 who are sorted? And just to say that EmpowerX Advisory Services is ready to assist and ensure that you get your wills drafted. So we've got Momentums and other providers available on our platforms. And I also shared our number and our email address there. So info@empowerx.co.za. And we've got some of our clients that are part of this session. And we're grateful to see that people are taking this for themselves and choosing to have their wills done and also their financial planning in order. There's a question on trust. How much do you charge to draft the trust?
We do have a fee schedule. I do not have it on the top of my head, but it's something we can obviously share with Muraro then, and then she can then distribute. Is that okay if we put it that way?
Yes.
Yes, we do have a fee schedule for that. I just don't have it on the top of my head. Happy?
Happy. And just to note, thank you to everyone that has joined in. And if people need to go, this is being live streamed to YouTube. So if you missed something, you can always go back to watch the remaining part that will be available on our YouTube channel. And this is the first video on the YouTube channel. So thank you, Momentum, for being the first one to add content into that channel. Thank you. We can continue.
Okay. Another very, very important aspect regarding the divorce and annulment of marriage. So in terms of Section 2B of the Wills Act, the moment you get your decree of divorce, you've got 3 months in which you change your will. Let me repeat that. The moment you get your decree of divorce, you've got 3 months in which to change your will. If this 3 months lapses and you die after the 3 months and you still have not changed your will, it would be deemed as though you wanted your former spouse to inherit from your estate. Hope I'm making sense. If you die within the 3 months, if you are fortunate enough to die within the 3 months, then it will be deemed as though you were never married and your former spouse will be excluded from inheriting from your estate. So the best advice is the moment you get your decree of divorce, change your will. Should I maybe repeat it?
It's very clear. And my colleague here says she would wake up.
I would wake up too. So moment you get your decree of divorce, change your will. That's why it's very, very, very important that you review your will as many times as you can. And that is Section 2B of the Wills Act. The courts, this I think I may have touched on briefly. In terms of Section 2.3 of the Wills Act, this is what we refer to as the rescue provision. So when you've got that document that you believe is valid, that once you lodge at the master of the High Court, and the master says, I'm not accepting this will, you can rely on this section, Section 2.3 of the Wills Act, wherein you are able to approach the High Court that will then compel the master of the High Court to accept that will as valid. Again, counsel needs to be briefed in order to appear at the High Court, or maybe an advocate. You know, they charge and they sell time. So it is an expensive process if you want to compel the master or if you want to approach the High Court. So litigation is very, very expensive. So if you have a proper will from the beginning, you don't even have to worry about Section 2.3 of the Wills Act. And even then, you can still approach the High Court, but it's not a guarantee. The High Court might still say, we are not accepting this will at all. And that's just the reality. There is a rescue provision that you can think of. Are there any questions on this aspect? Nothing. Okay. I want to quickly do the most important one, this one, freedom of testation. And I think after this one, I think I've touched on the important ones because I'm looking at the time as well. After this slide, we can actually conclude. But I think this is very, very important, freedom of testation. In South Africa, we do have the freedom of testation where you can bequeath whatever you want to whoever you want, as long as it's not contra bonus mores, which basically means contrary to good morals. So you can give whatever you want within your estate to whoever you want, however you want, as long as it's not illegal, immoral, or vague, or against the Constitution. However, you need to note that there are certain limitations to your freedom of testation, such as the following. If you are married in community of property, remember, it's one joint estate, or basically one joint estate, which you share amongst the two of you. So if you have a will where you leave out your spouse, you need to consider the fact that you are only dealing with your 50% and not the full 100%. So if you're saying I'm bequeathing that house, you are talking about my 50% interest in that house. You're not talking about the full house if you are married in community of property. Number two, if you are married out of community of property with the accrual system. So remember accrual, let me explain what an accrual claim is. You are out of community of property, so it's two separate estates. You've got the husband, you've got the wife, two separate estates. Now, the spouse with what an accrual claim is basically, we look at the two estates. The spouse with the bigger estate would need to pay the spouse with the smaller estate half of the difference between the two estates, and that's what an accrual claim is. So if you do have a spouse and you leave them out, they can still have an accrual claim against your estate, and that's something you need to consider, and that's a limitation if you want to leave out your spouse completely, that you are married out with the accrual claim. Again, if you made out of community of property without the accrual system and you leave nothing to your spouse still, your spouse can still have a maintenance claim against your estate in terms of the Maintenance of Surviving Spouses Act. So they can still have a claim against your estate even though you left them out of your will. Same applies to children. So obviously you've got the freedom of testation, but if you've got minor children, they can still have a claim against your estate because they're still minors. Something to think about. Section 37C, we've already spoken about. For those of you who are in businesses, buy and sell agreements, these have more authority than your will itself. So these agreements will be taken into account. Same applies to limited interests in properties or investments. Those need to be taken into account. Section 38, takeover, also something very, very important, wherein, for example, you leave your house to your spouse and children. Your spouse can make an application in terms of Section 38 and say, I would like to buy out the other beneficiaries within this house. And obviously, these beneficiaries need to agree to being bought out, and the master of the High Court would also need to agree to that. The last point, also a limitation. This can go against your freedom of testation. For example, you give your house in Polokwane to your daughter. You give your house in Mokopane to your son. Your son and your daughter then enter into a redistribution agreement and say, let's swap these benefits where you take the house in Mokopane and I'll take the house in Polokwane. And obviously, a redistribution agreement will need to be drafted by the executor. It needs to be endorsed by the master of the High Court. And in most cases, they can say, hey, this one is more valuable than the other. We endorse it on condition that money is paid over to so and so. And so they ensure that it's actually distributed in a fair and equitable manner when it comes to this. And this obviously goes against your wishes. So these are the limitations of freedom of testation, where you can bequeath whatever you want to whoever you want and so forth. Any questions regarding what I've just touched on?
There is one that says, so with a will, with no trust, my spouse or guardian can use the funds for whatever he please, like get remarried and not have funds available for my kids' schooling or my wishes.
So just say that again. I'm trying to, again, draw a picture. You've got a...
So with a will, with no trust, my spouse or guardian can use the funds for whatever he please, like get married, remarried, and not have funds available for my kids' schooling or my wishes. So in this case, there's a will, but there's no trust in place. Yeah. So will money be paid to the guardian and spouse, and then they go remarry?
The answer is yes. That's why you need a will. The answer is yes. That is why you need a will.
Okay, thank you.
Yeah. Makes sense?
Yes, it does.
Okay. And yeah, the next one is basically a case study that covers everything that we've touched on so far. And because of time, I'll just go to the concluding remarks. This is me just trying to be smart. Never underestimate the importance of proper financial planning in making sure that your will is executable and easy to administer. And always consider your business running without you and make sure that appropriate arrangements are put in place. And the choice of your executor, I think I've emphasized this throughout the presentation. Who you choose as your executor, very, very, very important. Ensure that they actually specialize in fiduciary. In other words, they specialize with wills, they specialize with trusts, they specialize with winding up estates. Make sure, very, very important. Because it's one thing to say, hey, I went to that guy in the corner there because he's a lawyer. That lawyer could be a criminal lawyer, but when you come with your estate, they're not going to turn it away and say, I'm not doing this. They're going to take it. And what do? They look at the piles of files and they focus on and I'm not bad-mouthing anyone. I'm just saying there are other people that are jack of all trades. There are attorneys out there and lawyers that actually specialize in these things, and they are experts in these things. So don't just go to anybody. Ensure that whoever you go to specializes in what you are going there for. That's what I'm saying. And obviously, these are my concluding remarks. I thank you very, very much to everyone that's attended the session. I really hope it was informative. Thank you very much.
Thank you very much, Tibatso, and thank you to Ingrid for ensuring that we do have this session. So from our side, we're getting comments as well, even on the WhatsApp group, to say this is a very informative session and people are getting to learn new things and also to get to unlearn things that they thought was in line with the will. And the last comment here that is posted is saying everyone must just get a will. It makes everyone's life easier. And yeah, so what I wanted to say in closing is to say you indicate proper financial planning. And the concern that I can voice out is that people do not want to make time for their own finances or their own financial planning. And sometimes they would want to focus on a will as just a once-off event. They do it, they put it aside. But if you look at the will, it affects each and every aspect of our financial plan. And with us, we just have a 2-pager fact-find document where people get to look at the different areas of their financial plan, but you send that to someone and they'll say, yo, that's a lot of information, but that information speaks to your financial planning and allows for a proper or quality financial planning to be in place. And when it comes to will, I say there's admin that needs to be done. There's fees that would need to be paid. So it's important to have a will in place now so that dealing with the will, they don't have. So it's better to have a plan in place and ensure that the admin is well taken care of and you've got professionals that are going to take care of that. So as well, from Ingrid, able to comment, and for everyone that has managed to join in the session, there is, thank you for this. I always thought I'd need a will once I have kids or get married, but now I know better. So 16 years and above, you can't say that you are 15. So 16 years and above, you must have your will sorted out so that we might not be found wanting when the time comes. So thank you, and thank you all.
Thank you. Bye.
Thank you.